You know your child better than anyone, but you may not know exactly how to work with the educational system to make sure your child is supported and thriving in school. I love the idea that it takes a village to raise a child. As many parents found out in our year of distance learning and stay at home, kids need both parents and teachers. Sometimes, when your child is struggling and you're trying to navigate the legal system as well as special education, that village may also need to include an attorney. Today, we're going to explore some of the questions that parents have around their child's rights, services, IEPs, 504 plans, and stay put orders. This is LD Expert Live. Welcome to LD Expert Live, your place for answers and solutions for learning differences, dyslexia, and attention challenges. I'm your host, Jill Stowell, founder of Stowell Learning Centers and author of At Wit's End, A Parent's Guide to Ending the Struggle, Tears, and Turmoil of Learning Disabilities. This book will help you understand why some bright children and teens struggle in school and what can be done to change that permanently. To get a free copy, go to parentsatwitsend.com. Let's say hello to Lauren, our moderator and the Director of Clinical Growth and Operations at Stowell Learning Centers. Good morning, Lauren.
Good morning. Hello to everyone who is watching us live. Let us know that you're here and where you're checking in from. We love to see all the places all over the world where people are watching us live. Parents, we have a resource for you, another resource for you, our private Facebook group, Mom Squad. That is a community of parents with kids and teens with learning and attention challenges. We share resources. I've posted several guides related to learning challenges, dyslexia, auditory processing, executive function resources, and then also parents supporting other parents. If you want advice from the group, you're welcome to post there. In order to find the group, you can go to our Facebook page and click on the link, or go to Facebook groups and search the keywords SLC Mom Squad to request to join. And today, our guest is an attorney with a real heart for helping children with special needs. If you have ever worked with an attorney or are currently working with an attorney, we'd love for you to post about how it's helped. Post in the comment section. Just let us know how that's helped you in your journey with your child. We already have some people checking in, which is great. We have Annie checking in from Pasadena, California. Welcome. We have Virginia checking in from Potomac, Maryland. Welcome. And Shirley checking in from Las Vegas. So parents, go ahead and post. Let us know if you have worked with an attorney and how that's helped. And we'll check back in a little bit to see what you've shared and answer your questions in a little bit.
Great. Thank you, Lauren. If you're just joining us, this is LD Expert Live. I'm your host, Jill Stowell. Our guest today is Alexis Casillas. For over a decade, Alexis has represented students with disabilities and their families in educational rights litigation at all levels, from administrative hearings to proceedings in federal trial and appellate courts. She has deep experience with every aspect of special education practice, from helping parents navigate the IEP process, representing clients in mediation and settlement, trying cases in administrative hearings, and challenging or defending administrative decisions in federal court. Alexis is now the legal director for Learning Rights Law Center. Welcome, Alexis.
Hi, Jill. Thank you for having me.
Well, we're so happy that you were able to be here this morning. Tell us a little bit about Learning Rights Law Center and your mission there.
So the Learning Rights Law Center is a great resource that's been around for about 50 years. It was founded by a woman named Janine Steele, who is an amazing attorney who experienced learning challenges when she was going through the educational system, and having struggled with that firsthand, eventually realized that her difficult experience wasn't necessarily a product of her not trying hard or any of the kind of internalization of academic struggles that she felt, but rather it was just a problem in the system, and recognizing that there was something to be fixed in terms of the educational system. She resolved to go to law school, and did so, went to UCLA, and then founded her own nonprofit, the Learning Rights Law Center, to provide free and low-cost legal representation to families who were, by virtue of some aspect of their life, be it disability or demographic disadvantage, were not able to access the same type of meaningful educational benefit that our public education system is intended to provide to all students. So it has existed for about 15 years, and it's grown to provide not only just the direct legal representation that we provide through the legal department, but we also have parent training programs, the Tiger program, where we teach parents, family members about special education law, and help them do kind of grassroots organizing and working with their school districts to make the system better and more accessible for the families. So it's a great organization.
Wow, it sounds like it. I love the story behind it, and there's a lot of good work going on there. I know you've also worked at a national level. So what is happening at the national level with special education law, and what are you trying to accomplish there?
So we're at an interesting kind of inflection point in terms of the development of special ed law, kind of on a broader level. As you know, special education really kind of came into existence the way we recognize it not too long ago. It was only 1975 that students with disabilities were actually given affirmative rights and protections that entitled them to be in our public schools. Before then, it was on a case-by-case basis, and so many students were just not even let within the front doors of our public schools. And since 1975, the IDEA has been in existence, so it's been called a couple different things. And Congress has routinely updated or reauthorized the law to add additional provisions as we learn more. When we know more, we do better. And so over the course of the IDEA's history, we've added provisions for early intervention. We've added provisions for transition. We've added additional due process protections to assist families in kind of navigating the system and enforcing rights. And the most recent reauthorization actually took place in 2000, getting finalized around 2004. And we haven't really had since then any kind of revisitation to what the broad special education picture is going to look like. So there's been a lot of rumblings about whether now is the time that the IDEA is going to be revisited, and what, if any, sections of law are going to be revamped or changed or added, things that we haven't even thought about before. So that's really exciting to kind of be kind of on the precipice of, and to wait to see what's going to happen in terms of the IDEA's reauthorization. Will it happen? When will it happen? And what will it mean? So that's kind of the statutory side of special education law. There's also been a couple of important legal cases that have come through. It's not very often that special education cases go all the way to the Supreme Court. And actually, in the last 5 years, we've had two. So we had the Andrew F. decision in 2017, and within months, there was also the Fry v. Napoleon County School System case, and both went all the way to the Supreme Court. One dealing with what is a free and appropriate public education for students who are not in the general education curriculum track, which was kind of an open question up until then. And Fry dealing with kind of a complicated legal question about how the IDEA exists alongside other anti-discrimination laws like the Americans with Disabilities Act and Section 504 of the Rehabilitation Act. So there's been a lot of efforts to kind of redefine special education law, and that's trickling down from the federal level into the states and the local school districts, and everybody's trying to interpret it. So a lot of change is happening. It's I don't want to say fun because there's a little bit of uncertainty, and that's always hard for us as attorneys and parents to deal with. But I like to see it as possibility. I think there's windows for us to really make a better system and figure out how to make everything work for students and teachers and administrators, and live up to the lofty aspirations of the IDEA.
Wow,
that was a lot.
But we don't often get to really hear kind of what's happening on a national level. So I really appreciate that. I said earlier that sometimes an attorney needs to be a part of the village that's coming around a special needs child. And there's a feeling, I think, that if you bring an attorney into the process, it will be adversarial. When should a family bring in a lawyer?
So I am very familiar with that fear. My youngest brother has severe autism. So I grew up alongside the IEP process, even as a child myself. So I vividly remember these conversations happening around the dinner table, and my family being resistant to the idea of tapping anybody else or bringing in an attorney because they didn't want to appear like that parent, or they wanted to be collaborative and deferential and work with the school staff who is proposing and implementing IEPs for my brother. So I absolutely understand that inclination. I think having gone through law school and become a special education lawyer to kind of work in the system, and done so for some time, it's given me an entirely different perspective, and one that I think is hard to grasp for any parent just because of the dynamics and the difference in dynamics between a parent's experience in the special education process and a school's perspective. Because most parents aren't repeat players in the IEP process. Some families have multiple children who qualify for special education and have to navigate creating IEPs, implementing IEPs, etc. But most families, when you start the process, it's going to be the first time. And so you don't really have kind of historical context or kind of a broader understanding about trends or how these meetings go, right? You have your annual IEP, your triennial assessments, and from kindergarten through diploma or age 22, there's only so many times you're going to actually have to sit through these meetings and do them. Whereas your school members of the IEP team have them weekly, multiple times a week, especially when you're getting towards the end of the school year. So they're very much aware of the flows and the processes and the kind of larger things at play that if you're just there for your student, you're not going to be necessarily aware of. So once you recognize that there is kind of a difference in knowledge base and input that's not equal across parent and school members of the IEP team, I think that should make it easier for you to realize that attorneys, because of the fact that they're going to IEP meetings on behalf of students, but usually multiple students in multiple school districts, they have that same knowledge and they can fill those gaps that you may or may not be aware exist between what you're coming to the IEP team table knowing and what everybody else at the team knows. I also think it's important to note that lawyers get kind of a bum rap, right? Like we're thought of as being these angry people who make everything a big fight, and that's not that's not the case. But particularly in educational issues, you may be surprised to know that special education lawyers are not super common coming out of law schools. It's kind of a rarer specialization. And the reason for that is because it is a pretty complex practice area that I don't think people realize the extra facets that special education lawyers have to know and be aware of. Special education lawyers not only have to know the law and be able to navigate legal systems, but we also have to have fluency and familiarity to be able to understand reports coming from all sorts of disability profiles and backgrounds, and have a much more multidisciplinary understanding of the law. And that tends to draw people who are willing to have a broader knowledge base. But it also, just because of the way schools work, I would say a lot of special education attorneys are very familiar with working within teams and trying to make those collaborations. We're staunch and zealous advocates. But I would say our field doesn't have the same type of scorched earth, win at all costs types of approaches you see in other fields of law. So oftentimes attorneys participate in non-adversarial approach and are able to do so in a kind of connection building, grow the pie kind of way. So,
and it sounds like there's just, a parent knows their child better than anybody, but there's just so much else around that whole special ed picture that they may not really know, and not know either what to ask for or, when to push back a little bit.
I think that's absolutely true. And it's one of the things that I'm hopeful will get more attention if the IDEA is reauthorized. Because for better or worse, like when you walk into an IEP meeting, like it's a team and we're all there for little Susie or little Jimmy, but a lot of parents report not feeling as though they're equal members of the team. And it's just intimidating when you sit at a table and everybody on it might be round, but everybody else at the table works together, and it feels like they have their own little approach, and that's absolutely true. Like school members of IEP teams are able to have pre-meetings. Like they have usually talked about your student and what the offer should be before you even get in the room. So I think we have to work hard to make sure that parents who do know most about their children and their children's needs and learning styles are really given the same type of platform, and their input is weighed the same as everybody else at the team, even if even if it does feel like it's not an even distribution of voters, even though it's not necessarily supposed to be just a vote at the IEP team. But
when we had talked earlier, you mentioned that families often wait too long. They want to see if what is being offered is going to work, and can you talk a little bit about that?
I think this kind of goes back to where we started, where there's a reluctance to bring somebody else in because you don't want to seem like you're difficult or fighting with the school in any way. So that's just kind of a feeling that families have to confront whenever they're deciding what to do with their IEP teams. But that plays to a student's disadvantage, right? Because there's this inclination to put off hiring a lawyer because that's seen as escalating or taking the situation into a different sphere or changing the dynamic. But along the way, there are a number of kind of in the weeds legal procedures that can be used to secure preferred programming or get closer to crafting a program that's in line with what you think would be appropriate for your student if there is a disagreement between you and the school district. And oftentimes by the point a family finally gets so fed up of hearing no and not being able to make the inroads that families expect the process should lead to as sort of a give and take, you've gotten to a point where you've been saying, for example, say you want to try a different educational therapy to approach a reading deficit, and a family wants to use this particular approach, and the district wants to use another approach with fewer hours, and that's, let's say, a hypothetical disagreement. We as lawyers know when in the development of that disagreement would be the most appropriate time, and the most beneficial time from the student's perspective to present that evidence. But if you haven't checked in with an attorney, they can't tell you kind of the types of evidentiary issues to be on the lookout for. There's also just the situation that as part of any IEP document or any change in programming, there are additional potentially long-lasting legal implications. For example, if there's a disagreement about placement, and a student's family wants the student to be mainstreamed for as much of the day as possible, and the district is proposing a more restrictive, more segregated placement. Oftentimes, we've had parents come in and say, well, the district wanted to move my child to this other classroom. I didn't think it was the appropriate thing to do. I didn't think it's what should happen, but they said we were just going to try it. So I said, okay, you can try it. But I thought that if it didn't work, we could get you back to the general education setting. And the way the IEP documents are drafted and the way placements are worded, families can often get themselves into a situation where they unknowingly have agreed to a permanent change, and they're not able to go back, even though they understood this to be a trial placement. So there are ways in which IEP offers and implementation of services can be crafted in the IEP document to more accurately reflect what the family's understanding is. So it's important, if there is kind of a disagreement, even if it's on the horizon and you expect that the trend in offers is going to be moving in a direction that you're not comfortable with, it's best to consult with an attorney or an advocate just to be made aware of the types of changes that could be being proposed and how to best protect you and your students' rights in terms of maintaining programming, trying new programming, etc. So,
yeah, I can see how easily that would happen, that you think something's going to be temporary or a trial, and you just don't really understand all of the language and all of the implications around it. I want to ask you about something called stay put. I know that is something that when a district and a parent don't necessarily agree on something and they're trying to figure it out, they do a stay put. And I would love for you to really help us understand what that really means and how it helps or could even hurt a family.
Absolutely. So it used to be like way back before the IDA, and even in the early stages of the IDA being in existence, when districts wanted to change programming, they could just do so. So if they thought a student to go from classroom A to classroom B, they would just effect that change and the student would be moved. But that's not the type of kind of team collaborative process that Congress contemplated. So this procedural protection, commonly referred to as stay put, was put into effect. And what it says is that during the pendency of any disagreement, the then current placement, or the student shall be maintained in the then current placement while you work it out. So say, for example, the district says the student should be moved from the Apple classroom to the banana classroom, and the parent says, absolutely not, I think he's doing great in Apple, we don't want banana at all. Stay put says that as long as there's a pending disagreement, the district can't move your student over to the banana classroom. And stay put can last as long as that disagreement's pending. So that can be just the time between IEP meetings, while it takes the team time to kind of work through a family's concerns and explain and convince the family that Banana is actually the appropriate place for this student. If that's not going to happen, and there actually is an underlying disagreement that requires the assistance of either an administrative law judge through a due process hearing or a finding from the State Department of Education's compliance officers, a complaint could be filed. And then as long as that complaint is pending, the student is still entitled to stay in Apple, right? Until the family has exhausted every opportunity to prove that Banana is not right, the student gets to stay in the Apple classroom, which is a very powerful protection for families. However, I mean, it's also something that we have to be aware of, because it can be used in the inverse. For example, a second ago, we were talking about a hypothetical situation where a family unknowingly signs a document that they believed to be an interim or a trial placement. But unless that document clearly indicates that the Banana classroom trial period was only going to last for 2 weeks, even though the family understood from the meeting that it was going to be an interim placement, if the IEP document signed, that becomes the stay put placement. And even if the family thought it was just to see if it works, the district can keep the student in that Banana classroom, even though the family believes that it wasn't supposed to be long-term or wherever. And again, the same duration applies. So the family will have to wait until they have exhausted and proved that Banana was not appropriate and it was not intended to be the long-term classroom. And that can last time. So just going back to my last comments, I think it is important just to be aware that there are ways in which you can have support through IEP document review and consultation and just background support, so that you are making sure you're not unknowingly getting yourself into a situation with stay put, or not aware of some sort of effort to create a record that would support a placement change that you don't think is appropriate. We all want to know what's right and appropriate, but there are ways in which you can track progress and get teacher reports or outside reports in a way that would support either option. So you have to be aware about kind of how the record is being developed, and what judicial trends are, to kind of know what you should or should not be developing in terms of your record.
Wow, there's a lot there. I'm going to shift gears just a little bit. We work with many students in the 2E or twice exceptional population. So these are kids who are extremely bright, but they also have learning disabilities or attention deficits. And the problem is that they're so bright that they can manage often. So then they may not qualify for special services, even though the parent sees them struggling every day. So what can a parent do in that case?
So I think I'd like to answer that with kind of two parts. The first being to acknowledge that the situation faced by 2E families is kind of a daunting one. I don't want to say more daunting, but it's a highly nuanced situation, because these are students who, because of their cognitive potential, are usually able to obtain within the average band of academic marks. And because of that, even if, for example, they would otherwise have been capable of much higher standardized academic performance, or non-standardized academic performance in just general grades, because they can kind of get by and do good enough in our general education curriculum, that's used against them and put forward as a reason by districts that they should not be eligible for special education, and they're not entitled to those types of IDEA or Section 504 protections. And that's not actually what the law provides for. So oftentimes we will have to fight for eligibility and services and supports for students who are getting fine passing grades, but they're impacted tremendously in terms of their social emotional presentation. They have high levels of anxiety. They have other academically related impacts related to their kind of disability profile, but they're not presenting in terms of grades or standardized testing. So that's something that our families know very well. But I see a lot of families being told, well, they're getting passing grades, so there's nothing we can really do for them. And that's not the case. But beyond that, not having IDEA or eligibility or a 504 plan in place does not mean that these families are not in a position to be able to support those students. Again, coming back to the idea that families know their children better than anybody else. If your student's struggling through a class, it is having such an impact that it's important to provide them outside tutoring or mental health supports or executive functioning coaching, whatever type of deficits your twice exceptional student is experiencing, you as a parent are going to be in a position to be able to know where you kind of need to help them. And again, coming back to the don't wait too long to reach out to somebody like us. We as attorneys are kind of able to help you navigate. Okay, you're not covered under the IDEA umbrella. Are there ways that we could get you protection support services under the Section 504, the Rehabilitation Act, or are there additional state educational program elements that would be helpful for you? Not even just in the traditional IEP challenge, but just in terms of making sure that your student is having a positive experience going through their K through 12 learning experience and even beyond. There are some educational attorneys who specialize on just the transition from K through 12 on to post-secondary education, or identifying appropriate placements for students who are completely academically capable, but by virtue of their severe mental health presentations require therapeutic schooling components or stuff like that. So it's a difficult needle to thread, and I like to think that schools, but especially kind of the special education attorney community, is doing a better job of kind of helping those families push back on the assumption that just because you look okay or seem to be keeping up, that means that you're not actually experiencing things negatively or worse than your neurotypical peers. So,
well, thank you for that. These are big questions, and I know that a lot of the challenges around the 2E population are coming to the forefront now as we all get more educated. So that's helpful. If you're just joining us, this is LD Expert Live. I'm Jill Stowell, founder of Stowell Learning Centers, and our guest today is attorney Alexis Casillas, the legal director for Learning Rights Law Center. Let's check in with Lauren and our viewers in the chat.
Hello. We have some more people checking in and saying hi. Ronke from Ann Arbor, Michigan is checking in. We have Jay saying, like you said before, Jill, when we were talking about that, parents, we know our kids the best, and sometimes we do need to educate the educators on our child and their needs and what's best for them. We have Andrea responding to our question. Hi from Vegas. I have my son's transition to kindergarten IEP meeting tomorrow. I'm using the help of an advocate for the first time. I felt the need for it because my son's school isn't getting the assessments done that I've asked for during the IEP revision meeting 3 months ago. She's talking about an FBA. I believe that's a functional behavior analysis. The only negative feedback I get from the teacher is about his behavior. He likes to talk to his peers and has a hard time staying on task and following directions, and a comprehensive OT assessment for occupational therapy. My son has severe ADHD, low frustration tolerance, low flexibility, and poor problem solving. So she found the need to get an advocate to help because the school wasn't as responsive for that transition meeting. And then asked a further question. She just asked, how do we make sure that during stay put, we were talking about stay put, the child will be supported properly and the teacher will still be doing her best to help the child succeed? I think thinking that maybe a school wouldn't be happy or satisfied with stay put if a parent disagrees. Is that ever the case?
It's certainly an ongoing concern. Again, like this ongoing theme about like, do I escalate and do I bring an attorney in? What's going to happen to my child when I send them to school, even though I haven't gone along with what the school is asking me to? And I will say that I have thankfully not really experienced many instances of kind of, we would call that retaliation against parents or students. So that's one thing I'm grateful for. But families should be aware that at the point that they or anybody on their behalf start advocating or putting forward arguments, positions, requests on behalf of their student that are based on their IDEA or Section 504, just kind of disability-related rights. There are laws, the ADA and Section 504 have anti-retaliation provisions. So if, for example, a school district gets upset that you have asked for an occupational therapy assessment and they say, well, that's it, I'm just not going to let Jimmy have recess. He's not going to get a recess because his mom is just asking for all of these assessments and I just can't believe I have to do all of this stuff. I can't imagine teachers doing that, but if they were to do that, that would be very problematic because the district would be subjecting themselves to liability and could be found to have to pay monetary damages for that type of action against the student. So there are great legal disincentives and protections in place to make sure that students, particularly when their families are doing disability-based advocacy, are not going to experience any sort of retaliation. And those protections actually apply to teachers. A lot of the case law you see applies to teachers who have spoken up against their administrators or other members of the IEP team and said, no, going back to our apple banana disagreement, I agree with mom, this student should be in the apple classroom. And sometimes teachers have felt that they have been then looked over or not promoted. And if teachers experience that type of retaliation, they should definitely seek support of attorneys. That would be typically an employment attorney, but we special education attorneys are well aware of the phenomenon for teachers and can make sure that teachers who are being treated negatively because of their advocacy on behalf of students with disabilities are protected, and we can make sure that they're taken care of so everybody feels like they can do what's best for the student.
Mm-hmm. We have Carla asking for some advice. My 8-year-old daughter was just diagnosed with epilepsy and we're doing a 504 for the fall. This is very new to us and we have so many questions and worries. What advice can you give us?
So kind of the first thing I'd like to say is I want to make sure that all families know that I completely understand the worry. I mean, this is our most precious things in the world that we're trying to put through this educational system. And I think we've come a long way in terms of trying to develop support systems so that families don't feel that they're as alone going through this. So I would advise you to reach out to parent groups to help you so that you just have a sounding board. You may not necessarily be ready to call an attorney, but there definitely are other lay resources to kind of help you through. One of the organizations that I'm very grateful for and work with is called the Council of Parent Attorneys and Advocates. and it was started in the 1980s. And though it originally began to connect attorneys and advocates who represent students, so people like me, it has since developed and now actually has a parent subgroup. And they have an annual conference, and they have a list where parents can come on at any point in time and say, I have an IEP tomorrow. I'm super nervous. Like, what kind of goals do you have for reading? Or you're looking at a 504 plan. So you can ask, is anybody in this school district or our SELPA, which is a coalition of school districts in a geographic area, does anybody know what kind of health plans or 504 plans are coming out of this area? So kind of trying to, again, even out the information gap that exists between school district members of IEP teams or 504 plan teams and parents who are coming to this usually as like you in their first instance. So there's COBA, which is kind of broad resource for families about process in the law. But there are also disability specific parent groups on the national, local level. And that can be another good resource to help you through and have another one of those sounding boards. But beyond that, without kind of getting into the specifics about what your particular 504 plan should include or what your eligibility question should be, I think the most important thing that I tell my parents is to really trust yourself. It's really easy when you get into this process and you have everybody else saying, well, we just don't see that. Like, that's not what we're seeing. For you to think, well, maybe I don't know my kid. Like, maybe I don't know. Like, but more often than not, like, there's usually much more truth to what parents are asking or observing than what is initially received and acknowledged when there are kind of those differences in observation. So just be willing to not only trust yourself, but also start thinking about how you can demonstrate your observations. For example, say a family is seeing their student really struggle with homework and they're just not able to do the work at home. You can report that to an IEP team, and the IEP team can say, well, there's no problem doing work with us. We're not sure what the problem is. But if you start keeping a log and you can say, like, on Monday, my student spent 3.5 hours on homework. It was 3 hours on Tuesday. We just didn't even do Wednesday because he couldn't get in front. Like, if you start collecting information so that you can say, like, this isn't just an anecdotal observation, like, this is my recorded observations, I can contextualize it. That's going to be helpful because even though I think our parental observations should just be acknowledged and taken, we do have this weird, like, familial understanding of our students that's going into a more clinical understanding of our students in these 504 IEP settings. So figuring out ways to bridge kind of that gap will be helpful. So those are my broad pieces of advice.
Great advice. We have a lot more heavy questions, so I'll try to go through them quickly so we can get to everyone. Shirley is asking, what do you think about the issue on evidence-based curriculum and methodology? Schools often state IDEA or IDEA mandates it's the school's choice, not the parent's choice, despite outside evaluation reports and lack of meaningful educational progress. And then she continues, we were told that providing FAPE doesn't mean the best, but just enough to get by. Any thoughts on that?
So I that's kind of two things, and let's start with the latter first. So after 1975, Congress set up this concept of a free and appropriate public education. Congress said, schools, you have to not only educate students with disabilities, you have to let them into the buildings, but you also have to provide them with a free and appropriate public education. but they didn't really define with all that much specificity what a free and appropriate public education meant. So in 1982, there was a case that went all the way to the Supreme Court that asked what was a free and appropriate public education. What does appropriate mean? And there's language in that decision that says students with disabilities are entitled to the Chevy, not the Cadillac. I'm sure many of your listeners have actually had that spouted to them in an IEP team meeting, because it has carried on, and it seems like a nice analogy to throw out in a meeting. It's actually not. Like, I never want to hear that told to families, because there's this weird disconnect, because we as parents want what's best for our children, but this concept in special education is that our children are only entitled to what appropriate is. So there is that push-pull that just exists no matter what. That being said, though, I think there's been slide in terms of understanding what appropriate is. We wrote, when the Supreme Court heard Andrew F., which was asking what is appropriate for a student who's not on a general education curriculum. In the papers that COPA filed, we talked about how since the Raleigh decision in 1982, where we had that Chevy versus Cadillac language, and since the initial passage of the IDEA, our national educational policy has really shifted, right? If you look back in the 60s and 70s, a lot of our civil rights cases were about access. People were excluded from being able to even come into the building and access curriculum. And that was a very important step for us to take in terms of our special education policy. But as time went on, if you look more at the 80s, 90s, and the early 2000s, broader educational policy was not just about access, but we started requiring our public schools to be much more thoughtful and accountable in terms of what they were doing with our students from 8 to 3. You saw the passage of laws like No Child Left Behind, and you saw the implementation of standardized curriculum and curriculum-based monitoring. And it is our position, and I like to think that the Supreme Court and Andrew F. actually acknowledged this, but it's our position that as that broader national policy about accountability progressed, those same expectations about students actually having to demonstrate benefit and districts having to be accountable to show that our students are moving along applies equally to students with disabilities who are able to access general education curriculum and students who are not. In Andrew F., the Supreme Court said that you have to have appropriately ambitious goals in light of the student's circumstances. And it's not just enough to say, well, a student was there and he was meeting 1 or 2 of his 13 goals, which was actually the setup in Andrew F. So all of that's to say that curriculum and how curriculum is working is something that is very much supposed to be live and being tracked by our IEP teams. The start of the question had to do with what happens if there's a disagreement between parents and school district in terms of methodology, particularly if there's been an outside assessment that says one is appropriate versus another. And that's going to be a specific case-by-case inquiry, but I feel like far too often we're given a blanket, well, methodology is up to the school district. And that is true to an extent, right? If, for example, Jimmy can learn to read on any number of curriculums, like Read 180 works just as fine as Read Naturally or language, literacy, and content. If a student is able to learn under any of those 3 curriculums that the school already has purchased and is implementing in all of its classrooms, a student and or his parents probably can't come in and say, well, I need you to use Orton Gillingham to teach my student to read. The problem comes in when a student is actually not learning to read in one of the district's standard methodologies. So what I tell my families, and what is actually what the law says, is that methodology is within the purview of the school district unless there's a question about FAPE. If the methodology the school wants won't enable the student to make progress. And again, depending on whether we're doing kind of an Andrew F analysis or a Rowley analysis, you're going to be looking at progress on either general education measures or goals. But if you're not making appropriate progress in the district's methodology, then families can come in and say, well, you don't just get to pick because it's not actually providing FAPE. So what the district has said is technically true, but isn't necessarily ultimately true if you can demonstrate that their methodology actually does not provide a FAPE.
Mm-hmm.
Okay. We have Ronke asking about older students. Her daughter is getting ready to transition into college, and she says, "I don't want to be that parent that acts late again. My question: how does accommodations help when students need to maintain a certain GPA in order to keep their scholarship or any other offer given when accepted into a program in college?"
So one of the areas that I think is not as developed as it should be in terms of special education law and kind of IEPs or 504s is this concept of transition. Because in the most recent authorizations, Congress acknowledged that we need to be better about setting our students up to be successful in terms of independent living, post-secondary jobs, and post-secondary education. And I think it's important that we start holding our K through 12 schools more accountable in terms of helping us achieve what our post-secondary goals are. So for example, if that student who's trying to maintain grades in order to transition over to a college program, if that student has an IEP, you can absolutely say as part of their IEP, their goals will be to maintain that GPA so that they can matriculate upon graduation. And you can be very specific in terms of your transition goals about what needs to happen in light of the student's post-secondary aspirations and goals. So kind of bringing the school, if you have an IEP, to develop transition goals that are in line with what needs to happen to maintain that scholarship or that that matriculation agreement that you have with your student's college of choice. If your student is not necessarily on an IEP, you can also do similar protections through Section 504, and you can talk to teachers and say, this is our goal, this is what we're hoping to do. Are there any accommodations or modifications that we can do in order to support the student? Particularly in light of COVID, you should be aware that different states are doing different state level things in terms of protecting students, particularly those who are graduating. For example, in California, all students are entitled to opt for pass-fail, and all of our Cal State universities are required to take that pass-fail, and that can't negatively impact a student in terms of their matriculation agreement or their admissions. And California has instructed even the UC system and private universities to follow suit. They haven't obligated them yet, but they're under advice to do so. So there could be additional state protections in place to kind of help your student. But one of the common things that we see, particularly during COVID, because like it's so hard to learn, it's so hard to be tested during COVID, what are we going to do? Is really working with teachers to allow mastery in different ways. If your student is struggling in like the straightforward COVID distance or not distance hybrid kind of approach. So if that's being able to submit answers explaining why a test question was wrong and showing mastery that you learned after the fact or additional time, or being able to answer questions verbally instead of in writing. There's any sort of number of ways to kind of make sure that your student can demonstrate his or her mastery in a way that's more in line with their disability profile.
Makes sense. Thank you.
And I just, before we leave this issue of transition plan, because this is one of the things we wanted to be sure and talk about, just because it's a little bit off of people's radar. And so I know when you and I talked, you really encouraged families in the last 2 years of high school to really start to be helping kids learn how to advocate for themselves and in their transition plan, kind of think forward, what am I going to need when I leave high school? So that you don't just, you graduate and then,
Fall off
and
a
then
cliff.
what?
No, absolutely. One of the things that I'm hopeful if we do get to develop transition more in the next kind of reauthorization of the IDEA or kind of push it through case law is we really need to have more specific and measurable, meaningful transition goals. For example, a lot of our students with learning disabilities are going to matriculate to 4-year colleges and universities, and rather than having kind of the standard so-and-so will attend a career fair and a college fair and will explore admissions or whatever, like actually targeting setting that student up to be successful. Like so-and-so will develop kind of a one-page flyer to hand to all of his teachers and his disability office at this college that explain what his needs are. And really making sure, like, beyond just having a student take a kind of accountability and be prepared to become their own self-advocate when they get there, making sure that student is prepared to start that process in a post-secondary world. Just because of the way triennial assessments work, it's not uncommon for students to have their triennial assessment in their 10th year or 10th grade year. But many colleges require you to have an assessment report within 24 months or within 12 to 24 months of when you get there. So being aware that if your student is going to get any 504 accommodations or ADA accommodations in the collegiate setting, they need to have an up-to-date assessment done maybe in their senior, perhaps their junior year, and kind of being aware of those moving parts is something that parents should be on the lookout for.
Wow, that's great advice, because I imagine it's a little bit different depending on the university. So
Yes.
they need to check with the disability office.
Absolutely. Annie has some questions regarding twice exceptional child, her twice exceptional child. She's saying, we're currently fighting for placement in a school that specializes in support for kids on the spectrum. Our 7-year-old is a textbook 2E student. Our district says that this school is not appropriate for our child because he won't be challenged academically as a gifted child, though he would be very much supported for his struggles socially and emotionally. The school says they can support 2E kids. And she adds, my child has a primary eligibility for autism, and we have an educational advocate, by the way. So she's asking for advice for this. How do they kind of get the district to allow this placement?
So I'm going to try and like step back because if you're from Pasadena, I can start thinking about like the players that you're actually interacting with. I will say, if you're working with an advocate, and if you haven't done so already, if there's going to be any sort of placement disagreement, it's going to be very important that you have updated assessment information, and you have somebody who, there's a Supreme Court case that talks about independent educational evaluations, and the language they use is that IEEs are supposed to give parents the ability to match the firepower of the school district. So if you foresee some sort of placement dispute down the road, which it sounds like you do, you need to start thinking about who is going to be my expert who could challenge the district's assertions and speak from kind of a scientific, data-driven way about what is necessary for my child, and why the district's representations that they could or could not support a twice exceptional student are not accurate. And you also have to start focusing your thinking and arguments to really target the specific factors that are at play for your student. If, for example, and I think your question posed that the school that you're looking at might not be as challenging academically, but it would be appropriate in terms of social emotional needs, then you really need to start contextualizing, and again, keeping that notebook about what is or is not working in terms of like the district programming, or what your student is reporting, so that you have in the moment recordings about why you are taking this position and believe that your student needs this particular placement. And start thinking too in terms of how you're going to use those observations that you have to respond to the district's arguments, which you can anticipate are going to be that a student, I would imagine that one of the arguments that you're going to be facing has to do with least restrictive environment. And that is kind of one of the broader concepts in existence in special education law. It started with the very first iteration, and Congress wanted, again, remember, this is coming from a time when students with disabilities weren't even let in the building. Congress has since then tried to counter that and said that to the maximum extent possible, students are supposed to be educated alongside their non-disabled peers. So districts will obviously be saying, my public school campus is less restrictive. It provides student access to more non-disabled peers. And you need to think about if that's really the case, because sometimes it's not, and there are weird, counterintuitive situations at play. I've seen students who, because of their social emotional presentation, are not able to make friendships or connections on a large comprehensive campus. It's just too big, it's too overwhelming, they just can't experience it. But if they're on a smaller non-public school campus, even though it's away from the general education population in the traditional sense, some of those non-public schools have non-disabled students, and because of the setting or just the way the school works, they're able to have more meaningful relationships with non-disabled peers because of the environmental factors. So again, this is all kind of overarching kind of broad things to be thinking about, but if you're working with an advocate, I'm sure he or she is advising you about getting an assessment, so that you have an expert and starting to think about kind of these factors and ways to answer district concerns.
Mm-hmm. Thank you. I'm going to switch gears again. Teresa is asking about residential placements. Why does a residential placement in California mean RTC, usually out of state, when there are less restrictive in-state residential or boarding school settings that can benefit the student?
So this has to do with licensing, and it all happened, I like to say before my time, but I might have been just that sibling alongside the IEP process. But in the state of California, as our state law developed in terms of institutions for people with disabilities. And again, if you remember, it wasn't too long ago where people with disabilities were just put away in broad state hospitals and kept there in awful circumstances. So the way the state addressed that way back when was to be very strict in terms of the circumstances in which California-based facilities could be locked, meaning the front door is locked and students or adults with developmental disabilities can be kept in a building where the doors are locked and they can't get out. And that came from a good place. We can sympathize and understand that what was intended was absolutely right and in line with what we want to have happen. We don't want people to be institutionalized. We want them to be in the community as much as possible. But one of the unforeseen kind of side effects of that is when you do have students, particularly in the K through 12 setting, who require more comprehensive programming in kind of a residential treatment center milieu, a lot of times those students are presenting with behaviors that make them less likely to just stay in an unlocked residential setting. And they would probably require a locked facility, but because of state licensing rules, you can't have those facilities in California, except in very rare circumstances. So that's why you see most of our residential treatment centers for students who need that kind of therapeutic boarding school approach existing outside of California. And that's initially very difficult for families whose children actually need that type of support to confront, right? Like, I'm sending my kid far away, I can't even go visit them. And one of the things that I like to tell them is, at least for that early transition period for students who are requiring that therapeutic boarding school approach, even if it were around the corner, kind of the behavioral and therapeutic programming that's going to be implemented would mean that you're actually not going to be helpful if you're stopping by just around the corner if they were close. And usually we like to think that those placements are going to be brief, they're going to be short, and then there's going to be a transition back with support so that we can start fading out that kind of more intensive programming. So that's not to say it's easy. It's always a very difficult kind of placement decision to make, but that's kind of the law behind it. And even if it were in California, it wouldn't be as much, it probably wouldn't be that different in terms of your day-to-day experience with the program. And also, you should keep in mind, even if it is far away, if your student is placed there through the IEP process, most SELPA rules provide for district funding for family visitation. So for example, if your student is placed at a program, a lot of them are in Utah. I haven't quite figured out why, but a lot of them are in Utah. And there are rules about how many times you can fly out to visit, how many days you can stay, what your per diem for meals and car rental, et cetera, are. So those are costs that are supposed to be contemplated as part of any school-based residential treatment setting offer. So cost should not be a reason that if your student's placed there by IEP, you're saying, no, I don't want that residential placement. I'm not going to be able to go visit my kid. That's supposed to be part of the program.
Shifting gears again, a question specifically about math. Laura has a question. Why won't the school listen when you tell them that math is too hard on the child? He needs to be in a slower class. Nothing's been done. My child is struggling in math. He has an IEP. I'm not getting anywhere with this. And she elaborates, he has ADHD and also a learning disability. I've told the school since day one about math, and they don't want to pull him out of regular class and put him in a slower class. Yes, he has an IEP. I even have mentioned to them about sending him to another school. They won't allow it. She's saying they live in Virginia and need help, really need help. This is really hard on my child. Any advice there?
So this is it. This is something we see very often, right? Where a student has a deficit in a particular area of learning, and you may or may not be getting offers or program suggestions that would actually account for just that limited area of need. And I'm not familiar with your school district, so I can't kind of give you the background information about kind of what's at play or what programming has been developed or funded or what training your teachers have gotten and why they're making those recommendations. But I will say one of the things that we encounter across the country universally is this concept that what the district has as part of it, their standard offer is what is there. And that's not how the IDEA contemplated educational planning. The IEP process is supposed to be very individualized. And if, for example, a student had a rare vision disorder such that he could only learn in a classroom that was painted purple, the IEP team is supposed to be able to come to the conclusion based on all of the evidence and the data and the assessments. They're supposed to come to the conclusion that maybe Johnny's classrooms need to be painted purple for that school year. So the IEP planning process is supposed to be based on this particular student's individualized needs. And how we see that at play often, particularly for students who are mainstream for a lot of their day, is that there is this constant question about, well, can we just pull the student out for math? So he'll be in the general education classroom for the entirety of the school day, with the exception of math, in which case, we're going to pull in for that hour every day, or how often they're doing math. I don't know if they're a block schedule or whatever, but we're going to pull that student for math, and they're going to go to a smaller resource type classroom, perhaps a special day classroom just for that particular subject area. And a lot of families and students like that option because they're with their peers, and then they're getting the more specialized approach with a smaller group. Oftentimes we're seeing, and this will vary state by state, but the state laws will guide how many students your resource teacher can have on their caseload. So it's more likely that he's going to be in a very small group working with a teacher who has kind of more specialized training in terms of teaching students with learning differences. And there are some times when that will work. There are also some students who just the mere act of being pulled out is just going to set them off. They can't confront that experience. It makes them feel different and targeted, and that gives them more anxiety that actually is counterproductive and makes them unable to access the pullout or just the general education setting because they're so focused on this experience that they have. And that's not uncommon, but for students like that, IEP teams really should be thinking about, well, maybe this is a student who needs to stay after school, or maybe this is a student who needs intensive math remediation over spring break or winter break. Because there are some students where if you just do like a 2-week math camp and kind of fill in those basic number sense math skills that continue to kind of interfere with higher level math learning. Once you fill those skills, then you might not need the same kind of pullout. But there is kind of this universal reluctance to offer programming that's not part of the typical offer. You experience more pushback when you're asking for something that's not kind of in a drop down. But if that's what your student needs, then I would really think about why that is specifically appropriate for your student and kind of what is going to be the solution. Because it sounds like right now you're stuck in going back and forth about what the district's proposing and you don't want it. But if you really are specific in terms of this is what I think will work instead, once you crystallize kind of that disagreement, they want banana, I want apple, then you know what the parameters of the disagreement are, and you can decide what makes sense in terms of challenging kind of that difference of opinion.
Mm-hmm. Thank you for that. We have just a couple other parents just weighing in. Thank you for doing this. My daughter needs help. I am lost in this. My oldest has provisional ADHD, diagnosed PTSD, anxiety, and she already has a 504, and it took 6 months of fighting with her school just to even get that. They just really don't want to implement it as it is. And then Ronki is also saying, thank you so much for that response. And Jill, thank you for recognizing this need. And it does definitely sound like there is a need, a lot of parents who need help, with their children. And so, Laura or anybody else that, is kind of at their wit's end with their child. I mean, it might even help to do a free consultation with us. Feel free to call us. We'll put up our contact information. And I know a lot of people are asking for Alexis's contact information. So we'll put that up at the end. And we have some questions regarding out-of-state parents. So just asking what state you're licensed in, Alexis. We have a mom from Vegas and another one in Mom Squad from North Carolina. Do you work with clients in other states?
So at the Learning Rights Law Center, no, we're Southern California specific. I will put another plug in for COPA because not only does it have the parent group that you can participate and be on the list and go to parent-specific trainings. They have webinars and an annual conference every year. But COPA also maintains a list of attorneys and advocates by state. So if you do need to be connected with somebody, COPA doesn't certify or give any sort of guarantee about the competency of the lawyers on the list. But typically, if you have somebody who's a part of COPA, they're participating in kind of the broader continuing legal education and trainings and undergoing all of the briefing that COPA's legal director and our government relations committee are doing. So you're more likely to encounter somebody who is up on kind of the legal trends that are happening on a national level. So if you do need help, that's a good place to start in terms of getting connected with an advocate or an attorney.
Perfect. Thank you. And thank you to parents who participated and asked questions. I think we got to everyone. If you do have follow-up questions, a place you can go for advice is our Mom Squad, our private Facebook group. You do need to request to join. We are trying to keep it just a group of parents supporting parents with advice and resources. So you can find that again on our Facebook page or by searching Facebook group, search the keywords SLC Mom Squad to request to join. And we also have another resource. Our Peace group is a parent support group that we meet each month on a variety of topics. And May's meeting is on auditory processing specifically. It is a hot topic as well. So you can join us. That's Thursday, May 20th at 5 p.m. Pacific time. So I look forward to meeting you then. Thanks to all the participation from our parents. Again, if there's any follow-up information or questions you have, parents, feel free to post to Mom Squad, and we'll post Alexis's contact information at the end of the show.
Great. Thank you, Lauren. Alexis, thank you so much for joining us. Wow, this has been a great discussion. What would you like to leave our viewers with today?
I'm just wanting to acknowledge them for taking the time to continue to be educated. I think it's, I think all parenting is hard, harder than anybody can ever prepare you for. But particularly when you have a student who's experiencing learning difficulties, it feels like an extra backpack that you have to carry along the way. And I just want to acknowledge parents because I know that it can be frustrating and feel isolating and hard. So just acknowledge you for taking the time to check in and listen to resources like what Jill's got going here at Stowell Learning Center, and just know you're not alone, and not to be afraid to tap somebody for help. If it's another parent, if it's an attorney, if it's a service provider, there are ways to make this easier for you. So
great. Thank you, Alexis. And thank you for the work you and Learning Rights Law Center are doing on behalf of underserved families in Los Angeles and surrounding areas. It's really needed and appreciated. Here is the contact information for Learning Rights Law Center. There are a number of resources on the website, so be sure to check that out. This is LD Expert Live, your place for answers and solutions for learning disabilities, dyslexia, and auditory processing and attention challenges. We're live every Tuesday at 10 a.m. Pacific. Next Tuesday, we have a really special show for you. 3 of our Stowell Learning Center parents will be joining us to talk about their journey to understand and resolve their child's learning challenges. We'll be talking about what it takes to permanently change learning challenges and why it works. Be sure to join us next Tuesday at 10 a.m. Stowell Learning Centers are open for remote sessions and screenings. We're also seeing students on site with all of the COVID precautions. If you would like a free consultation for yourself or your child, give us a call or visit our website at stowellcenter.com. Thank you again, Alexis, for the guidance and information. And thanks to all of you who joined us and who have been sharing and subscribing. We really appreciate you. We'll see you next week.